We are back with Dayne Phillips, our attorney. Dayne, it is good to see you.
Good morning.
Merry Christmas.
Merry Christmas to you.
How is the baby?
Doing great. She is a fireball. She's walking now, and
Now, this is her second Christmas, right?
It is.
So,
now, the first one, obviously, she was
just a baby in mama's arm.
2 months old. You know, actually, so right at 2 months when she had her first Christmas. So, not moving. This will be a fun Christmas. She'll be able to open presents and really get into it.
Yeah, it's a lot of fun, that first one. And she is toddling around, just running all over the house.
Everywhere. Climbing, you name it.
Yeah, that happens. And so just keep the pediatrician and the emergency room number on speed dial.
Trust me, if you turn your back on her for a second, she's gone.
That's exactly right. Well, how is things going? Now, you've been about a month or so into your own business, and you staying busy?
Yes, staying busy. About almost 45 days, 43 days, I guess, into it, and it's going very well. Everything's working out great. Got court this morning, right after we're done here. So staying busy, everything's progressing. Best decision I ever made.
Well, I'm glad that, it's tough. It's a commitment to be a small business owner yourself. Like you said, you're doing things you didn't have to do before. You're on typing, you're on filing right now, but a lot of that just comes with starting a small business.
That's right. I mean, if you're a small business owner, you got to pay your dues. And the one thing that's great about this country is that we have these opportunities where somebody can start their own business and be successful and be their own boss. And it's kind of, as they say, the American dream. So as far as that's concerned, although it's an incredible amount of work, time, stress, money, it's all good because it's a decision that I've made to be my own boss, and it's certainly one that I don't look back on.
Now, you're still doing criminal defense and appellate work mostly, and that's keeping you busy?
Yes, that's my two primary areas. Basically, criminal defense, criminal appeals, and then post-conviction relief. I also have kind of went into within probably the last year, maybe not quite year and a half, but definitely within the last year or so, kind of started doing nursing license defense, and I do really enjoy it.
So, what is nursing license defense? I've never heard of that particular area.
I have a couple of hearings this Thursday, actually. So basically, like attorneys, the nurses are professionals and they have a license, same as a barber, and there's plenty of other professions. There's about
LLR.
That's right. So there's about 40-something professions that are licensed through LLR. Attorneys are not licensed through LLR, but like I said, there's 40 or 44 professions that are licensed, and nursing is one of them. And there's a board of nursing, and if there's a complaint or an investigation put on somebody's license because of some type of misconduct, then
or alleged misconduct too.
Right. I mean, that's the whole point, is that it's the complaint and an investigation's being put in place. There's LLR has their own investigators, their own attorneys, and ultimately the board of nursing is separate, and they make their decisions based on that investigation of whether somebody's license they should get a letter of caution, whether the case should be dismissed, or whether they should get a private reprimand, a public reprimand, or whether even to suspend or revoke their license. I mean, people's livelihoods are at stake. So I certainly treat the cases just as important as any criminal matter, because someone spent the time of years of school, just the training,
thousands
the money,
of dollars.
And it's their ability to take care of their family, their occupation. And as a licensed professional myself, that piece of paper means so much. Although it's a piece of paper, you can't put an actual value on the amount of years that you put into it, the amount of money, and the fact that that's how you feed your family. That's how you take care of your family. So in the last year of doing these nursing license defense cases, I absolutely enjoy it. I find the nurses are great to work with. And at the end of the day, it's just important to protect their livelihood.
Well, now, in nursing licensing, I can see how people can make an honest mistake. I can see how people can make a mistake because who they're working for is not staffed well and putting too much work on them. And then there are cases where people have nefarious reasons for doing things they do.
So here's the thing that I've seen the most of, and that I knew about but wasn't that, aware of, and I think most of the public's not aware of it, is that most nurses, for the most part, are overworked. way overworked. They work way too many hours.
There's not enough nurses and too many patients.
That's right, and they are understaffed. So there's way too many patients, and the demands of the amount of hours that they have to work is really outrageous. So overworked, understaffed, too many patients to watch, and then the standard at which LLR wants to hold the nurses to is truly outrageous sometimes, because kind of that process is, if there is some type of alleged misconduct, one of the things after they the LLR investigates is they'll send a consent agreement for nurses to sign, and a lot of nurses sign these agreements without seeking the advice of an attorney. And I've rarely seen a consent agreement that I thought was appropriate. So what
are they consenting to?
Well, generally it's kind of a copy and paste from what I've seen on a lot of the consent agreements. And if it's somebody's first go round and they haven't been in no prior discipline trouble, what they'll see is they'll ask for a public reprimand, which means it's basically like a scarlet letter on your license,
sure,
saying you've made this misconduct, and all future employers, current employers, the public who looks up your license.
So there's a database where you can look it up.
Yes, everybody can see it. The public, everybody can see that you had this misconduct, read all about it, fine you thousands of dollars, make you go through all types of different courses. I mean, it's just the amount of stuff that's required in these consent agreements, I think, is way too punitive and held to a much higher standard. And most of the hearings that I've went to, the boards actually went with us and decided to give a private reprimand. Now, although there's no guarantee in going to the board could ultimately, if they wanted,
sure,
revoke your license. The only good thing about a consent agreement is if the board accepts it, you know exactly what you're going to get. Kind of like a negotiated guilty plea. But for the most part, I haven't seen a consent agreement that's sent by OLR from the beginning that I thought was appropriate. I mean,
and they just send us and stick it in front of you and say, sign here, and don't do much explaining.
They do. I think one of the things they've added over the years, from what I'm talking to other people and doing this and representing nurses, is now they've added in one of the initial letters is saying that you have the right to an attorney, you have the right to seek legal counsel, and I think that has been the difference. I think in the past that language wasn't there, because that's what I've been told. I can't verify that because I've only started doing this within about the last year and a half, but once they see this public reprimand and they do notice in the letter that they have a right to an attorney, a lot of nurses do that. However, I think it's important to note, when I go to these hearings, most of the nurses, a majority of the nurses, are unrepresented. They are representing themselves with their livelihoods at stake.
Now, prior to this happening, when these accusations come up, obviously they're probably suspended from their job during that period of time?
Sometimes not. Most of the time...
But what I would be thinking is, I can't even work. How can I afford an attorney?
Most of the time, they've been fired and they've found another job in the meantime. That's what I've seen. Now, if the license gets temporarily suspended, obviously they can't work at all.
Sure,
and that happens. That happens quite often as well. But a lot of times, they get fired or resign from the current job, and they seek a separate employment in the meantime, and they're working somewhere else. And that's while this investigation's pending.
How much weight is put on the pressures that they're having at their job, Dayne? I mean, you've got assigned 20 critically ill patients when you should have 5,
right?
And you complain to your employer that it's just too much. I can't keep up. None of us can keep up, and they're just saying, "Look, we're doing our best, but right now you just keep going." How much weight is put on the employer's liability?
Well,
and responsibility.
Now, from a civil standpoint, I think the employer's liability has got to be high, and the problem, and that's where you have a lot of these cases where the sad fact is it's very difficult to prove true negligence, and that kind of goes into a whole nother area. But what I'll say as far as the nursing license defense is that when someone's so overworked, that it's impossible to provide what we believe is the proper care, where they should have 5 patients, but they're having to take care of and essentially assist for every need of 12 patients, or however you want to say it. I've found that the board, when we're at the hearings, is very sympathetic to that, in the sense that they know these nurses are just overworked. Now, they're not going to give them a free pass because obviously they have a duty of care, but they are very sympathetic. I can tell, they can't come out and say certain things, but you can tell as we present arguments that they do empathize with these nurses, that it's impossible if you have 100 tasks to do within a set amount of time. Sometimes it's impossible to get it done. And if you make a recording error in the notes, that can get you before. I mean, I've represented a nurse who made a recording error. Just she listed the medication wrong. She gave the right medication. I mean, it's small little things can get you in trouble, and a lot of trouble.
Checking the wrong box on a computer screen.
Exactly.
Misreading a doctor's terrible handwriting. And
all it takes is for a complaint. Some of the other things I've seen is sometimes there can be drama at the hospitals, and if a nurse doesn't like another nurse,
a supervising nurse doesn't like an employee,
or just a coworker, it only takes somebody to file a complaint, and they can really jam you up and have just kind of get your life kind of thrown in a tizzy for a while.
Wow.
It's no different than any criminal case. If somebody's willing to lie, they can make your life,
sure,
horrible.
I wonder about that. I mean, we have had this explosion of ladies coming out against men in most cases in regards to sexual harassment. Roy Moore being the prime example. Was running for Senate. I think the election was yesterday or today. I can't remember which.
Yesterday.
Right. But never convicted of anything, and yet because of accusations. But who is to say who's telling the truth and who's not when you've never been taken to court? It's never been argued. You've never been represented. It's never. It's people can, as you said, people can lie about anything.
As a criminal defense attorney, it's one of those things where certainly I've seen false allegations, and the people in politics and people in the public eye, outside of the criminal context, I would say that not that they've kind of asked to be put in situations where these things happen, but when you're in the public eye, when you're a celebrity or you're a politician, I'm not saying anyone's asking for it, but when you put yourself out there, I think it's an assumption of the risk that people are going to have these allegations, and some of them seem credible. I mean, a lot of the people that's been accused that we've seen they've admitted to doing the conduct, so it's not false allegations. But what I'll tell you on just a base level, non-celebrity, non-politician, people make false allegations regarding sexual misconduct and domestic abuse all the time.
That's the ones that I've seen the most of.
And what I'll tell you is a lot of times of what I've seen, it's somebody's trying to get they're having a divorce for the domestic violence side. There's a lot of true domestic violence victims. South Carolina has a deep problem with domestic violence.
Sure.
So I'm not trying to minimize that, because I've seen it firsthand that we have a significant problem in South Carolina that needs to be addressed, of why we have such a high fatality rate of women, and that's incredibly sad. But I'll tell you, on the flip side, as a criminal defense attorney, I've seen a lot of people that's made false allegations, and it's been proven that it's false. It's not a he said, she said. It's been proven that one person lied, either to get another person in trouble or to get some advantage on a divorce.
Sure.
If it's a girlfriend or boyfriend trying to get back at a jilted lover, or somebody just trying to make sure they get custody of the children, or just to prove a point. And that's one of the reasons why I don't do family court work, is because every case is like, it's
I
always say it's the court of misery. It's you want the 3 o'clock in the morning phone call about somebody posted on Facebook, that something I didn't like. Be a family court attorney. It never ends, and people for a lot of times lose all logical thinking when they're in that courtroom. But what I'll tell you is, the false allegations do exist. I mean, that it's just a true nature of the thing. If someone's willing to lie, go to the police and lie about certain things, then they can make your life I mean, they can just turn it upside down.
Sure, they really can. Now, you said something a while ago that you've said a number of times, and I've never really caught it until today, but I don't know that I know the difference. What's the difference between appellate work and post-conviction relief?
Okay, so the best way to explain it is if you're convicted, if you go to a jury trial and you're convicted, it could be from a guilty plea, but those are very rare. But if you're convicted at trial, so say it was a domestic violence case, you're convicted, the judge gives you, however many years, let's say 10 years, and as a domestic violence, a high and aggravated nature. Somebody was facing 20 years in jail. Judge gives them 10 years in jail. They're found guilty. Judge sentences them to 10 years in jail. So they have an absolute right to an appeal, and what's called a direct appeal. So they would be filing an appeal with we have 2 appellate courts in South Carolina. We have the Court of Appeals and the South Carolina Supreme Court. All the initial cases go to the Court of Appeals. So they would be filing an appeal to the Court of Appeals, and it would only be for legal errors, not factual errors. All factual issues are for the jury, but all legal issues are ruled on by the judge. Post-conviction relief is when someone's direct appeal was either denied or waived, and it's, for the most part, the majority of the time, is looking at the attorney's performance, the one who defended them, whether they provided effective assistance of counsel. In other words, whether they did their job properly and whether the other person was prejudiced by it. In other words, did that attorney's level of performance, did it meet the standard it should have? And if it didn't, if it fell below that standard, would the outcome would have been different had they done their job the right way? In other words, deficient performance and prejudice. And the best way to look at it's 2 bites at the apple for the person to have their conviction reviewed, whether their constitutional rights were provided. And you have a constitutional right to have an effective lawyer. You have a 6th Amendment right to counsel, and our United States Supreme Court has said, since you have a 6th Amendment right to a lawyer, then you have a right to an effective lawyer. The right to a lawyer would mean nothing if you got somebody who slept through the trial or
sure
didn't know what they were doing or did something incredibly improper, which resulted in you being convicted. And if that happens, if an attorney doesn't do their job the right way, you can get a new trial based on that.
So on an appeal, it could be that the judge made a mistake or the attorneys made a mistake.
Well, mainly that there was a legal issue that the judge ruled on and made a mistake.
It could be that he did not let somebody's testimony in, or he did let somebody's testimony in, depending upon which way.
That's a perfect example. That there was testimony presented that was improper. The judge allowed it in. It should have been excluded. And because of that, it's a reversible error and should be a new trial. That's a perfect example.
And some of those things may be if the police officers did not get the proper warrant and they went in and they collected evidence without the proper warrant, and everything is fruit of the poison tree because it was never a proper search to begin with.
And a good example of a PCR issue in the same light would be that evidence was raised and the attorney never objected to it. Never said a word.
Okay, so your attorney should have objected and said, wait a minute, they never had the warrant they needed, and they went and got it anyway, and yet he just sat there and was quietly allowed it to go by.
Right, and it should have never been entered. That would be a PCR issue.
I got you. So it makes sense now to understand that both ways. Now, this time of the year, there's a lot of things that happen. You brought up criminal domestic violence. A lot of passion this time of the year. A lot of families get together. They overspend. One member of the family overspends. Tempers get mad. There's drinking.
That's the 2 things.
Yeah. Money and drinks.
Money and alcohol do not mix. And when you're low on money and you've had too much alcohol, bad things happen.
That's exactly right. And sometimes people end up in jail. I have seen, and as you said, I have seen misdirection on both sides. I have seen females kick a man in his genitalia, and when the cops get there, she's got a bloody nose because he smacked her for it, and it looks like he attacked her when in fact she attacked him. And
well, I'll tell you that there's some judges, they don't care what the female has done. I've had one judge, I won't say the name. It was a kind of a mutual combat case, he offered to take the guy in the hallway and fight him.
Really?
I was there, so I've seen it.
So he was one of the old school, you never hit a woman no matter what.
And I've appeared in front of several judges who have taken that position, that doesn't matter what conduct the other side has done, there's no such thing in their mind as mutual combat. Now, that's not what the law says. The law says, as far as mutual combat, if someone's attacking you, you can defend yourself without a doubt. But
no matter the gender.
Right. That gender is not part of self-defense. But there are some judges who do not see it that way and will send you to prison very quickly if you appeared in front of them on a domestic violence case.
And I would imagine that age probably plays a part, because in some cases, I mean, you know, when I was a little boy, you were taught you never hit a girl for any reason.
Right.
You know, and that's just the part. Now we occasionally see things in criminal domestic violence cases like snatching car keys or a cell phone. You know, I have seen men that are doing what police officers tell you to do: leave, don't stay, leave and separate.
Well, snatching the cell phone is important, because when they changed the law 2 years ago, what used to be a 30-day offense is now, as far as the base level of domestic violence, is now a 90-day offense. And if you were to snatch the other person's cell phone, so if a couple was in an argument and the guy snatched her cell phone and left, he would now be facing up to 3 years in jail, because one of the enhancements is that they've tried to prevent the other side from calling the police. So if there's any evidence presented to a police officer that one side took the cell phone of the other side, then that would increase it from a 90-day crime to a 3-year.
Wow.
And so you go from magistrate's court to general sessions.
Because it's a communication device.
Yes.
So,
and that happens every day.
Every day. Now the other one is car keys. I remember a very, very high profile case 10 or 12 years ago. Somebody that was working at a very, very high level in the governor's office that snatched a set of keys during a domestic fight, and kind of shoved somebody out the way so that they could leave. Not physically injured them, but just pushed them out the way, snatched the keys, and left. Which police officers tell you, in the middle of a mutual situation where the two sides are not getting along, the best thing to do is one side to leave. But he was charged with criminal domestic violence. Would you argue that one?
In a heartbeat. Based on those set of facts, that is not domestic violence. Now, of course, I'm sure the other side said there was a lot of other things at play, and that the slight push out of the way was aggressive and forceful and
body slam.
Fearful of their life and so forth. But what I'll say is, the other thing that I see as far as enhancements that a lot of people don't know about is a child being present. And the holidays make a big difference, because the children are not always in school, and they're going to be around more because it's the holidays, right? So when conduct occurs, drinking and arguing's going, if the cops get called and the cops believe that there is a domestic violence issue and your children were present, that's also an enhancement. What would take a 90-day crime now for domestic violence to a 3-year crime.
Wow.
So and a lot of times it says in the presence of the child, but a lot of officers read that to, are the kids in the home? And
so they could be in the bed asleep.
I argue that that's not what the law reads. The law reads that it's in the presence of the child. The child has to physically have to physically witness it. Some officers disagree with my interpretation of the law and believe if the child's in the home, that's enough. Again, I think that's an arguable point that can be made to the prosecutors of why the case should be reduced to the 90-day domestic violence. But if a police officer is called out and a child is present, that will take it from a 90-day to 3-year crime as well.
Well, now, a lot of people also don't understand this, Dayne, but there's a difference between fighting with family and criminal domestic violence.
Well, there was a big case that came out recently. The Supreme Court finally issued the opinion on Doe v. State as essentially a homosexual couple trying to make sure they had the same rights as other individuals, because our domestic violence statute had the specific language of essentially the gender based of male and female, and that there was a whole group of people being disenfranchised. In other words, they were being left out of domestic violence simply because they were of the same gender.
They're domestic partners instead of
right.
a man and a woman.
And, you know, in this country, we have equal rights, and that's ultimately where the court went down, is that we can't create a law that leaves out a whole section of the population. You can't. In other words, there's a whole group of people where you had domestic partners where people were not being protected. So it simply, you know, if there was a domestic violence situation, the other side would not get charged with domestic violence simply because they were a homosexual couple. And, you know, ultimately that's, as far as the law is concerned, equal rights as far as domestic violence. You know, that's not necessarily a marriage issue, because domestic violence is not limited solely to people who are married.
Right.
It's
right.
You know, domestic violence encompasses people who have a child together and people who what it says cohabitate. In other words, they live together.
That's the point I think I was trying to make, because I mean, I have been to families where Thanksgiving and Christmas you might as well put up a boxing ring, because when the cousins come and get a few Budweisers in them, it's going down.
Right.
But that's not the criminal domestic violence. It's just violence.
Right. Right. And the law is in place. We have assault and battery for when you and your cousin duke it out. But you know, the important thing to note is if two people were just living together and they have the issue, that's a domestic violence case if they cohabitate. But the way the law was before, that was only for male and female. It wasn't for the same gender.
Sure.
So basically it was leaving out a whole set of the population where you had, again, you know, equal rights as far as the equal protection clause. And so the court said that they struck that language of the male and female. So domestic violence law is now more broad and can apply to more people.
Well, you know, as well as most people who watch this show know, that I listen to the radios all the time, and I hear child swaps a lot. And Lexington PD does theirs at the sheriff's department, even though it's kind of silly because they do it at the sheriff's department, but because it's in the town of Lexington, the Lexington PD also has to go for the child swap. But child swaps happen when divorced or separated families are swapping a child back and forth for weekend visits or whatever, and they can't get along well enough to do that in private, so they have to go somewhere public, and a police officer has to be present while that happens. If they've been divorced for 2 or 3 years and they're doing a child swap and it gets physical, is that criminal domestic violence?
They have the child in common.
So the child is the key factor.
Yes. So I mean, you're never, you know, when they say that you're always tied to somebody when you have a child, they mean it.
Yeah, you really are, because the truth of the matter is, and like I said, I hear it all the time. You know, they'll dispatch a Lexington PD car to go do a child swap at the sheriff's department, and they literally just have to have a police officer standing there while the child gets out of this car, he goes and gets in that car. And it's sad to say that things have gotten to that point.
Well, that's the word I was going to use. That's just sad for the child.
Yeah, it really is.
Yeah.
But it does occur
every day. You know, and again, another reason why I don't do domestic work.
I wonder if that's included in the court order at times, that they have to do the child swapping.
It can be. I mean, anything can be included in that order, and a lot of times when you have those domestic cases where nobody's going to agree on anything, the domestic orders are very specific and very detailed and list out virtually everything that should be done. At least that if both sides have the right attorneys, because that way it leaves no wiggle room and avoids conflict and future law enforcement involvement.
Yeah. Now, holidays is also a huge time that we focus on driving under influence. You know, we've had well over 900 people now in the state of South Carolina die in 2017 in accidents on our roadways. A lot of them are alcohol or drug related, and we have to get out of the habit of saying alcohol related, because nowadays drugs are just as big an issue, not bigger.
Right. So our DUI law is not specifically exclusive to alcohol. So you can be found guilty of driving under the influence of DUI if you're on Xanax or any other type of prescription medication. And obviously with the opioid epidemic, you know, a lot of people are on controlled substances. They're taking prescription medications. And, you know, the sad thing is, it's a knew or should have known. If you're taking prescription medications, you could still be found guilty of a DUI even though you were lawfully prescribed those medications.
Yeah.
So that's important to note. So if you know how they affect you significantly, you need to not drive that car, because if you get pulled over, you could be charged with a DUI.
You know, my wife suffers from fibromyalgia, and she has a strong pain medication she is prescribed by a pain management doctor for that. I take the same prescription for arthritis. We both take it at night after we get home, because it really affects us after a long day. Is when we're in the most trouble. I can take it, and you can't tell I took it. My wife's sitting on the couch drooling on herself.
Right.
You know, and so it's the same exact pill, same exact dosage.
Right. The medication reacts differently with all people. So I would tell people, if they just got prescribed medication, to make sure they've taken it once before they get behind the wheel of a car, because you could have a life-changing moment right there if there was a fatality involved and they had that in your system. I mean, it could turn into a felony DUI situation.
Sure.
And it's for the most part kind of through no fault of your own. It's not something you intended, but that's not how the law reads.
Well, you know, I mean, it's interesting we bring this up. It's because this just happened in our household, and thank God we have a 15-year-old that has a permit that allows her to drive with a 21-year-old car. Because I got sick, we did the Pine Ridge Christmas Parade, and I went to Lexington Urgent Care. The doctor gave me some medicine. I went home. I took the medicine. I went to bed. Woke up 9, 10 o'clock at night. I could not breathe. My throat was so swollen. I could not swallow the pills that the doctor had given me. Literally could not swallow, period. I mean, it was terrible. I woke my wife up. I said, I couldn't speak. I had to write, take me to the hospital. You know, I'm not even breathing well. And she had taken her medication. So we had a 15-year-old, and I got into the passenger seat. I had not taken anything because I had been asleep that whole time.
Right.
The 15-year-old drove us to the hospital, and because Mama had already taken our medications, that she'd been up all day. We'd been in these parades and things. But literally, if my wife had driven me, even in that emergency situation.
Well, the emergency situation could actually be a defense.
Really?
Yes, the emergency situation.
Still not a good idea, but a defense.
Right. It could actually provide a defense. In other words, that it was a duress type situation of there was a life-threatening moment, and she had no other means but to drive you to save your life. There would be a built-in defense to that.
Sure.
Now, could the prosecution fight it? Absolutely.
Yeah, because in our situation, there's a substation for the ambulance within 3 miles of the house.
That's kind of the back and forth, but there would be necessarily a defense if they felt like
But people need to think about that. That's the bottom line. Is you need to think about that. And my wife was, thank goodness, she was the one that said, Caitlin, you drive, because I've already taken my medicine when going to bed.
Right, that was very smart of her. And the other thing I would say is, if you take medication and you go to a holiday party or you go to a happy hour with friends and you have a drink or two, if you've never drank before on your medication, you also need to know how that's going to possibly affect you, because you could maybe only have the 1 or 2 drinks and be honest about it. I've really only had 1 or 2 drinks. But if you've taken your medication,
the famous 2 beers.
Everybody's only had a few, right? 1 or 2. But if you really only had 1 or 2 drinks, but you've never had alcohol mixed with your medication, again, that can intensify the effects of that medication. And a lot of people, and I believe them, have had that happen, where they've got some new medication that the doctor's prescribed. They've drank for the first time on that medication, although they're probably not supposed to, but they've only had the 1 or 2 drinks, and a whole nother, episodic kind of thing happens. That it affects them so much differently than just the medication. So that's another thing to be aware of, and know that could possibly get you in a lot of trouble.
Yeah. Well, and how about checkpoints? A lot of checkpoints this time of the year. Do you have any specific rights when you pull up to a checkpoint?
So,
what if you decide to turn around before you get there?
So if you turn around, they're going to pull you over. All right. That you just need to.
That's a red flag.
Right. My best advice is, if you see the checkpoint, do not turn around. You want to paint a bullseye on yourself. That's the quickest way to find yourself at night at Lexington County Detention Center on Gibson Road. But what I'll tell you is, with the checkpoint, first, checkpoints are not automatically constitutional. There's specific rules and protocols that must be followed for a checkpoint to be.
Didn't know that.
Yeah, to be constitutional, because again, it's kind of you have a right to travel. The freedom of a seizure from the government, and a checkpoint is a seizure because you're not free to just go about your business. They are stopping you.
They're seizing my time, if nothing else.
Right. So the United States Supreme Court has said that a traffic stop is a seizure, which triggers their Fourth Amendment rights of you have a right to have unlawful or against unlawful, unreasonable searches and seizures. So there's paperwork that must be filed to show there's X amount of traffic violations in that area, and it's a whole long list of things that must be filed by the police. But once they file that paperwork, they can have a.
And who they file that with?
So it's essentially with SLED, and it's basically what they call a traffic safety point. And once they have this paperwork done and it's all put together, it's a report that you get. They can have a traffic safety checkpoint. So it's really to check traffic and for safety reasons, and not just to try to arrest people is the end round game of how they're able to do it. But if they fill out this proper paperwork showing that the statistics and all, they can do a checkpoint. And at that checkpoint, when you pull up, and I can't stress this enough, the only thing you have to provide is your driver's license, your proof of insurance, and your registration. Now, if you're the driver, again, your driver's license, your proof of insurance, and your registration. If they ask the famous question of how much have you had to drink tonight, especially if that's the first question, because that happens quite often, you don't have to answer that question. And there's nothing they can do to penalize you. Will that raise their suspicion? Will they probably ask you to get out of the car? Probably. Now, if an officer asks you to get out of the car, a lot of people believe you don't have to. You do have to get out of the car. All right? So what you don't have to do is perform field sobriety tests. If a police officer asks you to perform field sobriety tests, either the horizontal gaze nystagmus, where they do the pin test with your eyes, or the walk and turn, where you do the heel to toe, or the stand on one leg, the one leg stand as it's actually called, you do not have to do those tests. You can refuse those tests, and there's no penalty for it. There's absolutely no penalty, and you have an absolute right to refuse field sobriety tests. You have an absolute right to refuse any investigative questions like, where are you going? Where are you coming from? How much have you had to drink? Those are all questions that are not related to, those are investigative questions that are not related to the traffic safety point, because really what they're looking for is, again, you have a valid driver's license, proof of insurance, and registration. And then, of course, if they have any other, if they have a smell of odor of alcohol, as they like to say, then, or bloodshot eyes, that kind of thing.
Odor of marijuana wafting from your window.
Right, slurred speech. They would say that raises the reasonable suspicion to look forward. But again, if the officer asks you how much you had to drink, you do not have to answer that question, and you cannot be penalized for it. Of course, always being polite and providing that necessary information, but you don't have to answer any of those questions, and you can refuse the field sobriety test. What I think is important is if the officer does believe that he has probable cause for arrest of a DUI and he places you under arrest, he's got to read your Miranda rights, and that all has to be recorded under the law. And we've hammered that before, but our law requires that any field sobriety tests and you being placed under your arrest and you being read your Miranda rights must be video recorded. And if not, there's certainly a lot of legal issues that your attorney can use. Now, once you're taken to the police station, they have the what they call the data master, what people call the breathalyzer, but it's a breath test, and it's a data master in South Carolina. And essentially, you have to be notified that you're being video recorded, and they're going to check your mouth, and there's an implied consent form where they basically say you can refuse. You have a right to refuse the breath test, but there are penalties to it. If you refuse to do the breath test, there is a penalty. 6-month suspension of your license. Now, you have an absolute right to refuse. But if you do refuse that test, your license will be suspended for 6 months. You can challenge that suspension, but you only have 30 days to do it. Now, your blood alcohol content, if it's above a 0.15, then your license will be suspended for a month. If it's below a 0.15, or below a .15, your license is not going to be suspended. So you got to kind of weigh that cost benefit of whether you're going to use the machine. And a lot of other things, the Data Master doesn't actually read blood alcohol. It's a infrared kind of sensor, and it reads particles in the air. If somebody is a diabetic, that machine will trigger a very high BAC level because it's reading the blood sugar that's in the air.
Mm-hmm. Well, now, and we've only got a few minutes left, but when they ask you to do field sobriety tests, do they have to ask you if there's a medical condition why you shouldn't be able to do it?
So, yes, the National Highway Traffic Safety Administration, what they call NHTSA, has a manual that's this thick that has all the rules and procedures. And for each test, there's a specific set of questions that the officers are supposed to ask you and a specific set of instructions they're supposed to provide you when you perform those tests. Rarely do the officers ask you all the questions they're supposed to, and rarely do they give you the instructions as they're supposed to. And the test is very specific. The manual is very specific that it must be done this way. And that's, again, why having a trained and experienced defense attorney is very important, incredibly important. But what I'll tell you is, yes, if someone is 50 pounds overweight or they have knee issues, you can't be expected, because I know you have significant mobile issues. Your mobility is very limited because of your knee issues. We've talked about this before. There would be no way for you to stand on one leg or walk heel to toe properly. And what would be considered as an officer saying that what they would say is a clue of impairment, that's the buzzwords, they'd say a clue of impairment, is nothing more than your medical issue, which is why they have to ask that. And so for the horizontal gaze nystagmus, the eye test, the HGN, they're looking for an involuntary jerking of the eyeballs. So if somebody is under the influence of alcohol or drugs, if they hold the pin out, your eyes will twitch. Now, to me, it's junk science because there's 38 known causes in nystagmus, and simply being up for a long time, if you've been up 20 hours, your eyes can do it. Or you could have a medical condition if you've recently hit your head, if you take an allergy medication. There's a million different things, that can cause a nystagmus, which is why, ultimately you have to make the choice about whether you want to perform those tests. But I'll tell you, the likelihood, especially this time of year when I've dealt with these cases, it's freezing outside, it's 20 degrees, you're super nervous because you have an officer.
There's flashing lights everywhere.
Right. You're thinking, oh my God, my life's over. You're so nervous, you're shaking, it's freezing. You're not going to perform well on those tests. At least that would be my argument. Ultimately, it's the person's decision, but you have an absolute right to refuse field sobriety tests, and there's no penalty for it. There's no punishment.
We've got to go. Tell people how to get a hold of Dayne Nichols. I'm sorry, Dayne Phillips. I had a friend named Dayne Nichols once, but Dayne Phillips.
So I'm at 1614 Taylor Street in Columbia. I also have a little satellite office here in Lexington, right from the courthouse on East Butler Street. But you can call my cell phone at 803-807-0234, or you can reach my office at 803-272-4503.
And just to give you a little update, we are going to do some things with Dayne here in the next few weeks that we will post in the Ledger, and it will be in regards to that call you get at night from the loved one who's maybe been locked up for one reason or another, what to do, how to handle those situations, so that you'll be able to see those videos. And we'll be working those over, hopefully over the Christmas break with some of our interns. So we'll have a whole list of things that you can actually just go and click the button, and it will have Dayne giving them advice about what to do at that time. So that will be hopefully a good public service as well.
Well, thank you, Paul. As always, it's a pleasure being here. Certainly love to do it, and certainly would be love to help anybody that needs my help. If they call, it's not a 9-to-5 job, so I understand that. Never hesitate to call after hours. And again, Merry Christmas to everybody, and glad to be here.
Thank you so much. This has been Good Morning Lexington County, as we say every day. We love you and we love Lexington County. Good day and God bless from Good Morning Lexington County.
Take care.